días a todos. Bienvenidos a este webinar Estrategia bajo la incertidumbre. Hoy nos acompañan grandes expositores del reconocido estudio legal Clyde Co. Tenemos con nosotros a Roff, socia de Clyde Co. Clyde está presente en 50 ciudades, en 6 continentes, y tienen expertise en diferentes materias legales, principalmente en arbitraje internacional, proyectos y construcción. También le damos la bienvenida a Nathaniel Horrocks-Burns de Clyde Co, a Juan Pablo Halpern, socio de Halpern Pino, y a Mark Wainwright, director global de minería y metales de Turner & Townsend. Muchas gracias.
Muchas gracias, Carola, por la presentación. Yo aprovecho de agradecer nuevamente a la revista Minería Chilena y a B2B Media Group por la organización de este webinar. Y bueno, especialmente a Roff y a Nathaniel Horrocks-Burns por aceptar nuestra invitación a presentar sobre su experiencia en litigios derivados de la gestión de riesgo en los proyectos de construcción. En esta sesión, Marianne y Nathaniel presentarán algunos de los temas críticos que se han visto en los conflictos de construcción en el último tiempo, los que serán comentados por Mark desde la perspectiva práctica en la gestión de contratos de proyectos de minería y energía a nivel mundial. La pandemia de coronavirus ha tenido y seguirá teniendo profundos efectos en la industria de la construcción mundial. Probablemente seguirá habiendo retrasos sustanciales e impactos en los costos como resultado de la escasez de mano de obra, la interrupción de cadenas de suministro y la presión financiera, por lo que esperamos que se repitan las disputas que se han dado en estos últimos 2 años. Por ello, en estos tiempos de incertidumbre, vale la pena detenerse a reflexionar sobre las situaciones que repetidamente dan lugar a conflictos. Los expositores presentarán lecciones aprendidas en el último tiempo, no solo sobre cuestiones jurídicas, sino también sobre las situaciones operacionales del día a día de un proyecto. Más allá de la crisis sanitaria, estamos viviendo una auténtica revolución en nuestra manera de trabajar. Pretender volver a la normalidad aplicando los mismos contratos anteriores sería un error. Ayer conversamos del cambio en el enfoque que hay que darle al diseño de los proyectos para hacerlos más sustentables. Hoy queremos comentar acerca del cambio de enfoque de diseño de los contratos, principalmente a partir de las experiencias que nos dejan los conflictos más recurrentes. Sin más, ahora desde Londres los dejo con Marianne y Nathaniel.
Muchas gracias, Juan Pablo, y lo siento que voy a hablar en inglés y no en español, pero muchas gracias por la oportunidad de hablar. So I'm going to speak in English now. I hope there's going to be a translation. And Carola is smiling, so I think all is good. But it is an absolute pleasure to be speaking with you, and thank you very much for this opportunity. We all work in very large projects, complicated construction projects in the energy and mining sectors, and they are by their nature complex, they are often expensive, they involve many parties, and for this reason there are often many risks and difficulties that we have to cope with. And of course the current world situation has simply added to those challenges, as Juan Pablo was explaining previously. Of course we have the pandemic, and that has created huge pressures on the global supply chain. We've struggled with shortages of manpower, we've struggled with shortages of materials, and there has been insolvency, obviously, of many businesses. And on top of all this, it is a good thing that we're all thinking about climate change, but of course the drive towards carbon reduction in our projects also adds further challenges. And many of you will have heard of the case in May last year, which was brought against Shell in the Dutch courts. And this is the first time that an order has been made against a corporation directly to reduce its carbon. They were required to reduce their carbon by 45%, which is a huge percentage. That case is being appealed, but it is not going away. Again, you may have read You may be part of a company that has received letters recently from the environmental organizations that brought that case against Shell. They've written to 30 other major companies to require them to publish what they are doing about carbon reduction. And those high-level global pressures are being felt on projects now, and we are starting to see those who are constructing projects requiring that carbon reduction be part of the way that contractors run these projects. So as well as the cost pressures that you have, as well as all the technical pressures, you will also need to take steps to keep carbon reduction at front of mind. So all of these things are difficult, of course. Having said that, it is very easy to state the basic principles for delivering successful projects. I think we all know what they are. They are around careful risk allocation. They are around effective communication. They are around strong project management. It's very easy to state those things. Very easy for me to say the words, and very hard for those of you who have to deliver projects to get it right. So what we're going to do today, Nathaniel and I, is just share some thoughts with you about some key risk areas and some things that you perhaps can do to address those risks. We're going to talk for about half an hour, so we should have lots of time for questions, so please feel free to start thinking about your questions now. And I'm going to ask you, Nat, to move on to the common law versus civil law slide, because this is the first topic that we wanted to touch on. We thought that it was a great opportunity, with Nathaniel and I coming from an English law background, coming from a common law background, to share with you, working in a civil law environment, some of the differences in approach. And I know that many of your contracts may be under Chilean law, they may be under other civil law jurisdictions, but you might find that your disputes, if you do have any, will be under, it will be in London, or will be in New York, or will be in some other environment that has a common law approach. So really having an understanding of those different ways of approaching things may well be helpful. So I wanted to touch very briefly on what some of those key differences are. First of all, common law systems are not codified. So we do not have a book, a civil code, which sets out the law or the fundamentals of the law in one helpful place. Not conveniently, we have a case law based system. So the law is always evolving and comes out of the cases that are decided by the judges. So it's quite difficult, I think, to keep a track of common law systems. That's the first point to make. The second point, and it's really important, is that the parties have freedom to contract under common law systems. And what I mean by that is that the parties are very much bound to their agreement. Now, I know that's true in civil code jurisdictions as well, but under English law, for example, even if terms are unfair, or feel that they are unfair, or feel that they are uncommercial, the courts will generally uphold them unless they are illegal or contrary to public policy. But generally they will be upheld. And that's tied to the next point as well, which is there's no overarching principle of good faith in common law countries as there is in civil law, which again may seem terribly unfair, but often in English law cases, things which may seem unfair, things which may seem uncommercial, if they were agreed by the parties, the courts and the arbitrators will enforce them. So do not think that the courts and the arbitration tribunals will put right something that is wrong in your contract if you drafted and negotiated it wrongly. The next point is just around limitation periods. The limitation period is the period during which a party can enforce their rights under a contract. And they are different in every legal system, really. So it's just worth being aware of what the limitation period is for your contract. Under English law, it's 12 years for a contract signed under deed. It's only 6 years for a contract signed under hand. And 6 years is not a very long period of time for construction projects. So it is always worth being aware of when your limitation period expires. Next point, English law has, again, a bit like the fact that we don't recognise good faith. We also don't recognise gross negligence or willful misconduct as a concept of law. We only recognise it if it is written into your contract. So if you want to have those provisions applying to your contractual situation and you're under a common law contract, then you need to make sure that you include contractual provisions to that effect. And the final point, I think, is more about, again, the management of disputes or the management of issues on your project if they start to arise. I'm afraid that Nathaniel and I are going to talk about record keeping and documents very frequently. We're going to bore you very much on that topic. But the reason is important, and it's that under common law jurisdictions, there are often very rigid, very strong obligations about disclosure of documents. So even if you do not want to disclose a document, even if it sets out something which is contrary to your case, you may be obliged to disclose it under common law jurisdictions. So you have to really think about that and really be careful about what you put in writing and who you share that information with, which is, again, sounds obvious, but in the heat of the moment when we're busy running projects, you wouldn't believe the things that I've seen written down and the sort of language that sometimes gets used. So please bear in mind that some of the things that you write may end up getting read out in court or read out in front of an arbitral tribunal, which can be very embarrassing. So on that note, I'm going to hand across to Nat, who is going to say a few words about risk allocation and force measure.
Thanks, Marianne. Yeah, I'm going to talk, as Marianne said, just briefly about risk allocation and force majeure in projects. And obviously, this has really come into focus in the last 2 years with the onset of the pandemic. There's been a lot of focus on force majeure clauses in contracts and other equivalent clauses like hardship provisions. And whilst I'm no expert on Chilean law myself, I've read that there was much debate around whether parties could rely on the doctrine relating to changes of circumstances, known as teoría de la imprevisión. And there's been calls to codify that doctrine to make sure that it's recognized by the courts. So, whilst force majeure clauses and other similar clauses have had a great deal of attention throughout the COVID-19 pandemic, generally what parties have discovered is that they are not a magic solution to all of the problems that have arisen. In particular, so whether COVID-19 and its consequences constitutes a force majeure event for contracts entered into before the pandemic, and the relief that's available, if that is the case, ultimately depends on what the contract says. So it's really dependent on the drafting that is in the contract. Then in terms of relief, certainly in the UK, the issue of causation proved particularly problematic for parties trying to rely on these force majeure clauses, because there was a requirement that parties show they were unable to fulfill their obligations under the contract as a direct result of COVID-19. So in many cases, what this has led to is parties under contract searching for alternative routes to recovery. So, for example, we've seen a lot of focus on change in law provisions in contracts. This very much depends on what the contract says as well, but it also depends on the approach taken by the local governments or authorities who are responding to the impacts of the pandemic. We had quite a strange situation, to give you an example, here in the UK, where the government in Westminster didn't actually enact any legislative changes, rather they issued guidelines, whereas obviously, so that meant that parties operating in England were not able to rely on change in law provisions under their contracts to seek relief. But conversely, the Scottish Parliament did enact changes to their legislation. So you had contractors and parties to contracts operating either side of the border between England and Scotland who were able to access relief under their contract or not. And this depended on the approach that had been taken by the government. Another way we've seen parties seeking relief, if they've not been successful in relying on force majeure clauses, is looking to place relief on instructions or correspondence that's issued, and use that as a way to effectively assert that there's been an agreement on a solution or a proposed approach to manage the impacts of the COVID-19 pandemic. Again, the way this works depends on what the contract says in terms of instructions, and it will generally turn on specific facts. But clients do need to be wary, in particular, of any instructions or other correspondence that could potentially validate a particular approach to addressing risks associated with the pandemic, because this could potentially be used as a counterparty to seek relief under the contract. So whilst there is uncertainty and unpredictability with regard to the interpretation of force majeure clauses and other clauses in contracts that might give some relief to parties, the pandemic's definitely highlighted the importance of clearly drafted force majeure clauses that allocate risks in a way that's acceptable to the contracting parties. And really what we've seen during the past 2 years is a shift in the way that force majeure clauses are viewed and used. In particular, it's generally accepted that the pandemic wasn't foreseeable before early 2020. However, the position is obviously much less straightforward when considering issues that have arisen during the intervening 2 years as a result of the pandemic. Things that Marianne touched on, things like material and labour shortages and price increases associated with those. So the pandemic and its impact on the construction industry is now largely foreseeable, and as a result, it's increasingly difficult for parties to rely on a force majeure clause, for example, within a contract. So parties entering into new contracts now need to carefully consider all of the foreseeable risks associated with COVID-19, and as Marianne touched on, the other major risks that have developed over the past 2 years, including, for example, the risks associated with climate change, which has really been in the spotlight over the last couple of years. And they need to price their jobs accordingly and reach a commercial agreement in the contract that allocates risk proportionately. I think the other thing to note is that the issues from the pandemic have also forced the parties to adopt a more collaborative approach to contracting generally. The adversarial approach, which is enshrined in many contracts, often increases the risk of disputes, possibly leading to abandoned projects and insolvency. And it's been said that sometimes fighting for everything may ultimately leave you with nothing. So you need to take or parties have needed to take a pragmatic approach to supply chain issues, offering extensions of time and loss and expense where there might not necessarily have been a contractual entitlement, but there's a recognition that forcing a subcontractor into insolvency, relying on contract provisions to do so, might ultimately be counterproductive if you can't find an alternative subcontractor to do the same job quickly or at all. This is particularly important in an environment where there are increasing rates of insolvency among companies in the construction industry. So the supply of replacement subcontractors is not what it once was. Whether parties do manage to find collaborative approaches to completing projects or agree strategies for ways forward given the impacts of the pandemic or not, in circumstances where a dispute is notified, good record keeping is absolutely essential. So in a dispute scenario, obviously you'd need to justify your claim or your defense by reference to contemporaneous documents. But equally, it's important to have good records if For example, as a contractor, you want your client to agree to a price increase as a result of, your collaborative completion strategy for the project. Even if the client is prepared to accept increased costs, they're definitely going to be expecting to have the opportunity to properly audit any costs. So the good record keeping is particularly important. I'll pass now back to Marianne, oh no, sorry, I'm not passing back to Marianne at all. I'm going to tell.
That's because I know that you are.
Change management in the service of notices. As with any large infrastructure projects, inevitably involve things changing or not being quite as initially expected. So you can have issues relating to the design not working, or delays in the delivery of materials or equipment, changes in the ground conditions, and obviously the other risks that we've touched on today, talking not just about the COVID-19 pandemic, but also risk relating to climate change, geopolitical risk. In particular in Chile, there's the recent election, so the new president will be taking office in March later this year, and there's also constitutional reform on the horizon following a referendum a couple of years ago. All of this increases the possibility of change occurring during the course of a project. So with that in mind, it's really important to look at the contractual provisions. There are often very detailed and strict provisions about what parties need to do if changes arise. And in particular, there are always, in construction contracts, detailed provisions relating to notices. So I've put here on the slide here, notices. It's something that I'm sure lawyers will drone on about to endlessly and constantly be reminding you that you need to look at these provisions, know how they work, and make sure you get your notices in. And importantly, you comply with the timescales that are set out in the contract. Some of them are particularly short. For example, it might be 14 days. If you as a contractor need to notify a client of an event that gives rise to additional time or money. And the issue is that if you fail to comply with those provisions, some of them are drafted as conditions precedent. So there's effectively a time bar if you don't comply with that provision. And so parties often from civil law jurisdictions or from different contracting cultures find it quite difficult and impossible to believe that a party's rights could simply fall away just for failing to put in a piece of paper in time in serving your notice, particularly when the consequences of that might be that you end up facing liquidated damages. But a notice provision where they're drafted clearly will generally be enforced. Certainly that's the position under English law. And this applies even if the consequences are extremely harsh. As Marianne said, the differences between the common law, civil law approach, the fact that it might result in a harsh situation is by the by. It doesn't really matter, and enforcement will happen. Also, there's the point about good faith, which again, Marianne touched on. It could offer a reprieve in some certain civil law jurisdictions, but it's potentially dangerous to rely upon it entirely. You need to bear in mind also that a civil law contract might ultimately end up in arbitration before a tribunal that is constituted by members who are from common law backgrounds as well as civil law backgrounds, and some of them might be minded to take a more common law approach in delivering their decision and their award in the arbitration. Certainly, this is something that Marianne and I have come across in the past on cases where you have a client from a civil law background and then a tribunal where there are common law background tribunal members, and the reliance on the good faith principles under the civil law jurisdiction are called into question by these tribunal members from a different contracting or a different legal background. Then again, if you're going to avoid disputes, which hopefully you're able to, you need to make sure that your project team is fully aware of all of these detailed provisions relating to notices, and also has the capacity to comply with them. So look at your contract, consider what the administrative burden is likely to be with administering it as the contract is intended to be administered. You know, if there are notices, which is often the case with many forms of contract, you need to ensure that you have sufficient number of people so that you don't find yourself in a situation where, because one or two members of your small project management team are on holiday, for example, you miss a notice period, your rights fall away, and you end up facing liquidated damages as a result. So now I'm going to pass back to Marianne, who's going to talk to you about discrepancies.
Yes, that's right. Thanks, Nat. So Nat has touched on change management, which is a key area where we see disputes arising. Another key area where we see disputes arising is in relation to discrepancies in the contract. So what I mean by that is that one part of the contract says something different from what the other part of the contract says. And often what this actually shows is that the parties were never quite sure how a particular piece of work or a particular element of the scope was to be handled. And the contract never really grappled with that properly. And what we often see is a lack of consistency between what I call the front end of the contract and the back end of the contract. So the front end is the part that we lawyers agonize over and spend ages drafting, and it's all those kind of legal and commercial terms that you have in the conditions of contract. The back end is arguably the really important stuff. So it's the works information, it's the technical detail and the specifications of what you're actually supposed to be building. And very often we see that there is a breakdown between those two sides of the contract. So in terms of drafting and putting your contract together, it's really important to try and ensure that consistency. One of the examples that we often see, unfortunately, is around design responsibility. So a contractor will generally want to have a standard of care of reasonable skill and care in relation to design responsibility, rather than fitness for purpose, which is obviously a higher standard. But you'll often find that there is something tucked away in the back of the contract, which in effect imposes a fitness for purpose type obligation. And the famous example under English law was the E.ON and MT Hogard case, which was an offshore wind case, where the contractor was under a duty of reasonable skill and care, but tucked in the back of the contract was an obligation to achieve a design life of a certain number of years. So in effect, it was a fitness for purpose obligation was imposed on that contractor, even though they didn't know that that was the case. So watching out for those discrepancies is a really important way of trying to manage your risk. I've put there interpretation of the contract points relating particularly to the order of precedence clause. So in most contracts, you will see an order of precedence where the contract says, if there are discrepancies, you look first at this part of the contract, next at this part, and so on. And people often rely on that as being a way to achieve clarity, even if there is a lack of clarity in the contract. Unfortunately, certainly under common law contracts, you have to try very hard to construe the contract as a whole first before you rely on the order of precedence clause. And certainly judges and common law arbitrators will work very, very hard to try and make different parts of the contract make sense before they look back at the order of precedence clause. So I think the warning there is, do not think that that's a get out of jail free card, because it isn't necessarily. I think in terms of some tips to avoid disputes, really proactive management of risks and issues here is really important. So if the contract is not clear, is ambiguous, you still have to deal with that somehow, and just ignoring it and letting delays mount up, allowing the program to stay as it always was, that is only going to make the situation worse. So, trying to update the program, trying to be proactive in the management of those issues is important, and good record keeping. The final point, as ever, is an important one. Nat, if we just move on to the next slide, we've tried to talk so far about a few things to think about when you are negotiating and drafting your contract, and also when you are when you're managing it. So the points around notices, etc., and getting that side of things right. Sometimes, however, you do your very best, but you still end up in disputes. Sometimes they're inevitable. You're just too far apart. And then you have to start thinking about risk management at that stage. So what can you do to develop a dispute management strategy, which helps you find a solution to this, which keeps the project on track, which often is going to be your number one priority during the course of the project, but obviously also manages your liability and risk in terms of potential cost. So there are a few quite practical things that you can think about here. The first thing is thinking about the key facts that you need to prove. That may sound obvious, but having a careful think about actually what are the main issues that we need to prove here, prove them, is an incredibly important exercise to do. That exercise will lead you to thinking about what documents you need and where they are, and making sure that you gather them together. I've put there on the slide early consideration of document management, because certainly the cases that we look at, the sooner that you can get your documents onto a management platform, into a format in which you can search them properly and organize them properly, the better. So early consideration of that, I think, is important. The other key thing to think about is, who are your witnesses? Who are the people who know about these facts that are important? Where are they? Are they still within the organization? And if not, can you still keep in touch with them, etc.? Once you've thought about the factual side of things, you also need to think about experts. So what, if any, are the matters and issues on which you need expert evidence, whether that be a delay expert, whether it be somebody looking at the technical and design issues, or whether it be somebody looking at quantum. Choice of experts is incredibly important. Having some system in place as to how you choose them, getting some sensible advice about who has the relevant expertise, very important. And again, worth thinking about sooner rather than later, even if you are, touch wood, nowhere near the courtroom and nowhere near the arbitral tribunal. But you do start to need to think quite early about arbitration. Where does your arbitration take place? I mentioned before that I know a lot of contracts in Latin America, albeit they will be under Chilean law or Argentinian law, whatever it is, they may well have London as their seat of arbitration. So you need to think about what the implications of that are. What is the arbitral institution that you're going to go for? What are the advantages and disadvantages of that? Are you going to provide for having just one arbitrator, or are you going to provide for three? There are pros and cons of both. If you have three, it's a lot more expensive, but equally, you then get a range of opinions and views from those people, which may be helpful. So all of that is important. I think it's important also to think about your dispute management team. And that means both your internal team within your organization, but also your experts, also your external lawyers. What is the team that is going to give you the best chance of success? Giving some early thought to that is really important. And I put timescales and delay there, really with that point in mind, that you have to get on with these things. You have to start thinking about them earlier, rather than losing your tactical advantage and not getting yourself organized in good time. So I think that whole exercise of really taking some time, thinking about what you want to achieve and thinking about the team that can help deliver that for you is extremely important. Then moving on to think about, well, actually, how do we resolve our dispute best? Do we have to go to arbitration, or is there a different way of doing it? In the last few minutes, I'm going to hand back to Nat to talk about that.
Thanks, Marianne. Yeah, I'm going to touch very briefly on some of the pros and cons of arbitration versus litigation, and then talk to you about the alternatives for resolving disputes, and the pros and cons of those. So first of all, just talking about arbitration versus litigation in the courts, there's a long list of potential pros and cons, but I'll just touch on a few. I think the first one to mention is cost. So I think historically arbitration has been seen as a cheaper alternative to court proceedings, but it's not always the case, and it can be particularly expensive. There are administrative costs involved, so the arbitral institutions fees, venue hire, travel and accommodation costs for your parties, the legal team, the witnesses and the experts, albeit there were some savings during the pandemic with people moving to virtual platforms to hold their hearings. Also the tribunals fees and disbursements, and just by way of example, we've recently seen an invoice put in by an arbitrator who's one of a three-member panel, and he was charging $150,000 for the third installment of his fees. So it can certainly mount up and get particularly expensive if you're running an arbitration. Also, it depends on the approach taken by the tribunal. I think if you have an experienced tribunal and cooperative parties, which is key, then between those people involved, you can find ways to minimize costs and increase efficiency. And efficiency kind of moves me on to the next point, which is speed. So again, arbitration historically has been seen as quicker and cheaper than litigation, but again, it's not always the case. It can depend on which courts would have jurisdiction when you're comparing arbitration and litigation. So for example, in the UK, we've got a specialist technology and construction court with specialist judges who are able to deal with the complex technical detail relating to construction cases. And generally, they're perceived to be quite efficient and speedy. You might contrast that to another jurisdiction where perhaps the courts do not have that reputation, don't have that specialism. And in those circumstances, you might go for arbitration instead. A few other points to consider would be things like the flexibility arbitration gives you. It's been particularly useful in the pandemic, where local court systems have been overloaded with a backlog of cases due to lockdowns and not being able to have hearings or being slow to move to virtual hearings. The arbitration is a consensual process, and so the parties are able to agree alternative methods, either moving to virtual platforms or agreeing to change the timescales or the rules that are going to apply. So those are some of the pros and cons. But moving on to alternatives to dispute resolution via either arbitration or litigation, there are, the pros and cons definitely depend on the specific mechanism or procedure of alternative dispute resolution that's used. The term ADR covers a wide variety of different procedures, ranging from informal negotiation through to much more structured processes like dispute boards and adjudication, which I'm going to come on and talk to in a moment. So generally, I think the key benefits of ADR would be time and cost saving. It's generally quicker than running a full arbitration or litigation process. There's flexibility and control. I touched on the flexibility that arbitration gives you. I think there's a greater degree of flexibility in alternative dispute resolutions. It's not necessarily based on a win-lose outcome as well, which can be particularly important. It's much more solutions orientated. You can cut through the legal or the technical issues and maintain commercial relationships, which again is hugely important. You can achieve settlement through alternative dispute resolution, so you can reach agreement, but even if you don't, it can be a valuable tool, because even if you don't achieve a settlement, you can narrow the issues in dispute or perhaps re-establish lines of communication that have broken down due to a dispute arising. but it may well lead to settlement at a later date or make that more likely. The drawbacks would obviously be they're generally non-binding procedures, albeit some of them produce binding or interim binding outcomes. I'll mention those in a moment. And there's the risk that delay and wasted costs will come into play if you're unsuccessful through pursuing alternative dispute resolution. So mediation is one of the most popular ways of looking to settle disputes. I think it's key there. The consideration of who is appointed as the mediator is really important, because ultimately the mediator's role is to help parties see their cases from a different perspective. And that mediator can also help, avoid or even break deadlock situations that have arisen from direct negotiations between those parties. But conversely, it's not always suitable. Where a relationship or trust between parties is completely broken down, for example, if you've got allegations of fraud or other serious wrongs, then it might not be worthwhile even pursuing. Another alternative is expert determination. So this, in terms of the benefits, it would be quicker and cheaper than an arbitration process. Could be particularly useful for technical disputes, because you can appoint an expert who has specialist expertise and experience in a relevant field to look at an issue, analyze the technical detail. Obviously, the flip side of that is expert determination can be less useful where you've got a factual or a legal dispute. I've seen it used, for example, in joint ventures where there was a discrepancy between the parties to the joint venture about who was responsible for which parts of the project. The key objective for the joint venture as a whole and for its members was to find a way to reach agreement on this so that they could continue with the project and not get distracted by wasting time in an arbitration. It would reflect badly if the client that they were working for ultimately found out that they were all in a major dispute between each other. So it was useful. There were interim binding decisions issued by the expert. So effectively, they were binding, and the parties stuck by the decisions that the expert gave, but they could later be challenged in an arbitration. I'll talk quickly about dispute boards as well. So the aim of a dispute board is to proactively manage problems as they arise. They usually comprise a panel of 3 impartial individuals who are selected and appointed by the parties. They can have varying expertise from different fields. So you might have technical or legal expertise in the panel, or a combination of that. You can appoint the dispute board on either a standing or an ad hoc basis. So a standing board would be appointed by the parties at the outset of a project, and they would visit the project, say, 3 or 4 times a year, and generally keep an eye on progress and be updated so that they could have oversight of problems whenever they arose, and issues could be easily referred to them, with the parties safe in the knowledge that these people know all the background to what's going on the project and can quickly help find compromises rather than needing to go to a full dispute. An ad hoc board is simply convened as and when issues arise on a project, and the reason for going for that over a standing board is usually the cost factor. They're more suitable because of that, in larger projects. I think I'm running a bit over time, Marianne.
I was just going to jump in that and say maybe just a couple of words on adjudication.
I was just going to move on to that. Yeah, in terms of adjudication, the final point here is this is, you may ask, what is it? You may not be familiar with it. It's a form of dispute resolution that's common in some parts of the world, and it can either be a statutory procedure, or you can see it specifically written into contracts where parties are aware of it and want to use it. It is a binding dispute resolution process, which can also be final. So if you don't like the outcome of the adjudication, you might not necessarily have to stick with it, and you don't necessarily lose your right to arbitration. It's a very quick process, usually around 28 days, even for complex disputes, which is quite difficult to get your head around when you're used to lengthier processes like arbitration or litigation, and particularly when you can be talking about massive sums of money involved. It's really important to get the choice of your adjudicator right, to make sure you get a sensible decision. There's generally only one adjudicator. Similar to arbitration, there's obviously lots of procedural traps for the unwary. And so if the contract might allow you to refer a dispute and you refer several disputes, you can get into problems there. And the other thing is to bear in mind is they can be launched with little or no warning. So you can you can spring an adjudication process on your counterparty, and they'll have a very short, say, time period, say a week, to provide their first response, and you might have had months to prepare a full claim letter with expert reports and witness statements, etc. And then the other party, because of the nature of the process, just is forced to respond very quickly. So I think that's a run through quickly of adjudication, but as you can see, there's lots of different alternatives to disputes, and various considerations need to be taken into account when you're deciding which one to pursue, which one to put into your contracts as well.
Thank you, Nat. And that concludes what we were going to say. I think I'll hand back. I don't know whether to Juan Pablo or to,
Yeah. Thank you very much, and Nathaniel. It was a very good presentation. I have several questions, but before moving to the questions that the audience has sent us and the questions that myself have of your presentation, I will pass the word to Mark so he can make his remarks and comments on your presentation. So please, Mark.
Thanks very much. I'm going to be very quick. More time for questions, the better. Just to pick up on a couple of points that Marianne and Nat mentioned and give some practical implications, I think, of some of the points they were making. In terms of disclosure and documentation, not quite sure of the audience here, but if you're a lawyer, then please, in the business we do, going in and supporting the owners, that document management system saves us an awful lot of time if we're busy assembling information for dispute. So it's not an option from a SharePoint through to a very complex Aconex document control system. We really recommend that either to your clients or directly to the audience. The scale of effort required that Marianne was talking about, some sort of a project management basis. We worked on a Chilean claim some years ago, I think somewhere in the region of $100 to $200 million. Never quite sure of the settlement figure. And we assembled a team to prepare for the lawyers, prepare the files for the lawyers, of somewhere around 10 people for 8 months. So you can see the kind of effort that is required. One, if documentation is in a poor state, and I'd venture to add that probably 70% of that time of that team was actually in digging out data rather than thinking about the strategy for the client to lodge their counterclaim. The other point to mention on documentation is often we see clients leaving, and rightly so, dispute to the end of the project. They want to get the project into it. They want to get ore on ship. So a lot of the institutional knowledge of the background is lost as people go off onto the next project. So again, echoing the need for very good document retrieval. Risk, I think risk was mentioned. Perhaps surprisingly to a lot of you, we still encounter clients in the market who say, we've written up an EPC contract with our lawyers, so the risk transference is over. It isn't. The risk transference always lies with the owner because the owner takes the financial implications and doesn't really want to get into dispute. So an EPC contract is not a means of washing your hands of any kind of management responsibility as an owner to take that project through to completion. I think in terms of that contract, one has to be very careful of the supply chain, whether it's hot, and the ability of the contractors to provide, for want of a better word, the A team. You've got to look at that and then secondly, in times of economic hardship, clearly then cost of contracting is very important, and margins are slipped. And while not directly saying it, profit can be made out of poor control of engineering design, incomplete engineering, even in an EPC contract. So very important that the owner has in place the proper controls to try and mitigate some of the actions Marianne and Nat were talking about. And it is at the end of the day worth it to think through early, as was mentioned, and to put adequate focus onto mitigating that claim from a financial perspective. It will be well worth it, as well as a reputational and management time perspective. That's all I wanted to say, Juan Pablo. So back to you.
Thank you very much, Mark. I think you made an important point, and I had a question about it. What do you recommend, Nat, Marianne, and Mark? This question is for the three of you. To an investor that is not a huge company, so he will not have a big owner's team related to notices and time bars. So having a detailed contract with time bars, with notices, or having a more simple contract and with no time bars, and not caring of having a big team or hiring or outsourcing a big team to do the notices and to take care of the time bar. What do you recommend? Nat?
Oh.
Marianne, please.
I put my hand up because I think you were suggesting the answer in the way that you framed the question, Pablo. But I as Nat was saying, parties can find that they tie themselves up into knots by their contract. So they sign the contract thinking, oh, it'll all be fine, without actually thinking, well, we don't have enough people to be able to administer this contract. We don't have enough people to be able to keep an eye on all these notices. If you require a notice to be served within 14 days every time something happens, and then you require that 14 days after that you have to give lots of detail and information to back it up, and then you require that after a month you have to renew that, it's just madness if you don't have the team in place to do that. And some clients do have the team in place. They're very sophisticated, they're very focused towards project management, they can cope with contracts which have a great deal of project management tied into them. But some don't, and you have to choose your contract accordingly. There is a standard form that is greatly used in the UK and other jurisdictions. I'm not sure it's greatly used in Latin America, but it's called NEC. And it involves a huge amount of project management. So if you're not up for that, then don't use an NEC contract. Nat, you're nodding. I don't know if you've got anything.
Yeah, no, I mean, I'd agree with all of that. I think the other situation is you find yourself in with a contract that does have these notices and all of these provisions, and you don't have the team. You need to really consider whether it's worth the investment in bringing in people who can do that, or at least making sure that those who are involved, if you have a small team, are absolutely clear on the requirements and the obligations relating to notices. And for example, simple points like coordinating. If you have a team of two dealing with this, if one of them is on holiday, the other one needs to be looking out for things like this, because if you have very short periods, 14 days or even less, there can be some serious consequences if those time bars are in there.
Well, I think there are many people in the audience, especially in my office, feeling that they have experienced what you have mentioned, that you have to work like 4 people when you have a small team trying to cope up with the notices. Do you have any example or recollection of a case where the tribunal or the courts waived these time bars and conditions because notices were not presented accordingly to what is regulated in the contract?
I think, Marianne, sorry if I just take this one quickly. On a case that actually Marianne and I were working on quite recently, we had a situation where there was a contract that was definitely drafted more from a common law background, and it did contain notice provisions that were arguably conditions precedent, and we had a counterparty who hadn't complied with those notices from, that counterparty was from a civil law background, they were relying on the civil law or aspects of civil law which provided relief in certain circumstances from giving notices. And they were relying on that solely. But we had the situation I touched on earlier when we were talking about the constitution of the tribunal. Not all of the tribunal members were from a civil law background, or even from, had experience of that particular jurisdiction's laws. And so serious questions were posed, and the tribunal was not prepared to simply accept the proposition from the civil law contractor saying, it doesn't matter that we didn't serve any of these notices, irrespective of what was in the contract. So it's just something that parties need to be particularly careful of, because you may find that even if the law of the contract supports you, or there is some support for you in that jurisdiction's laws, ultimately, if you're before a tribunal that has different ideas, you might not be able to rely on it.
I think just a very quick practical point as well. If on site you all agree that this is all too difficult and we're not going to serve notices in the way that the contract contemplates, then that's fine, but you then need to record that somewhere. And the same case that Nat and I were talking about, one party were saying, well, we agreed you didn't have to serve notices, and it was fine, and everyone was in agreement on, but there was no piece of paper that said that anywhere. So again, it's you may be able to step away from the contract by agreement between the parties, but then you need to record that.
And in the same line of thought, the back end and the front end are, if the back end, the tribunal or the law governing the contract will be common law, you think that the lawyers drafting the contract should be common law lawyers, or there is no need of having common law lawyers drafting the contract if the project will be then, or any dispute will be then settled in common law?
Well, if it's a common law contract, I think it's safer to have an overview from a common law lawyer, just as I would think if it was a civil law contract, I would want to have a civil law lawyer looking at it too, just because there are, it's the things that you don't know about, it's the unknown unknowns. It's the things like, the examples I gave, you assume perhaps that gross negligence would have a meaning under English law. It doesn't. Consideration as a specific meaning under English law around, having to give something in return for a contractual offer. There are just quite a few loopholes that you can flow through if you don't choose a law which you know about or which your lawyers know about. So I do think one has to be very careful there.
And in that respect, when you have a project that is abroad in a civil law jurisdiction like Chile, where contractors are familiar, or the advisors and lawyers of contractors are familiar with civil law rather than common law, do you recommend that the owner, which is familiar with common law, to select a jurisdiction of civil law in order to have more coherent relationship with the contractors, or at the end that doesn't matter?
Juan Pablo, I think it's difficult to make a sort of sweeping statement on that, because it depends what you want to achieve in that project. I mean, I think your point about coherency means the answer is probably yes, but there may well be other reasons, for example, around the funding of the project. You might find that the funders are insisting on a particular jurisdiction, particularly legal approach. You may find that certain legal approaches and jurisdictions are more favorable in certain ways. So I talked about limitation. You might want to choose a law that has a particular approach to limitation, which will suit you. So I do feel it's probably more of a project by project answer to that one. I'd be interested in your views, actually, Juan Pablo, on that point.
Thank you, thank you. I don't know, Nat, you want to mention something?
Well, I was just going to say, if you have a situation, it goes back to what we've discussed already, but if you have a situation where you have those operating the contract being from a civil law background, for example, whereas the contract will ultimately be governed, or disputes will be governed by either under common law or by a potentially common law tribunal, then I think it's important to make sure that during the project, those who are running the day-to-day management of the contract are aware of some of these pitfalls that Marianne and I have flagged up, rather than, as is often the case, waiting until there is a dispute or there has been a request for arbitration has been received, and only then considering, oh, should we have been thinking about this in a slightly different way. So yeah, getting some advice on board during the course of the project can be helpful if you know that there's maybe a mismatch between the civil common law approach.
Very good recommendation. Mark, do you have any comments on the topic?
I just wanted to give it a bit of a context. I think with the scramble to net zero, with the commodities required for decarbonisation, and we talked about it yesterday actually, the extent of construction, expansion, new build is going to accelerate in the mining sector. As with the last boom, I think there's a possibility, a very strong possibility of more disputes, simply because the volume of work is going on. And I do want to add our experience thus far in dealing in the renewables space, where you have overseas contractors coming into Chile, not as sophisticated as the long-standing mining EPCs and EPCMs. We're finding behaviors and lack of good contract, poor contract management, because sometimes these builds are somewhat smaller and definitely simpler. If one thinks of a wind farm, for example, not a complex project. But there's going to be a readjustment period with renewable asset build in our view, due to the lack of sophistication. So as some of the clients on the phone, would-be clients on the call are probably experiencing, there's going to be a real need to protect yourselves in that space against difficult suppliers, and with different legal views as well. And I'm sure you can come up with various countries who perhaps think differently about many of the regulations that we used to in Chile and the rest of Latin America and the West.
Thank you, Mark. We are 3 minutes above the hour, but I think we have time for the last question. Is coming from the audience. I will combine two questions coming from the audience, and is, in your opinion, which are the main uncertainties or the factors of uncertainties within the mining and the energy sectors? And if you think, and you mentioned our political changes in Chile, Nat, in your presentation, if you think that factor is as important as others, or we should be concerned, considering that Chile has 30 years of political stability. So which are the main factors of our uncertainties, and if you think that political changes are a main factor?
I'll go first. I wanted to pick up actually on what Mark has said, which is that with the race to net zero, etc., a lot of organizations are moving into renewable energy sector, and that will be a growing sector everywhere. And a lot of those organizations are new to the renewable energy sector themselves. So, everyone's learning, that kind of thing. Certainly in terms of there are a bunch of companies who are used to working in the energy sector, but not necessarily in construction. So if they're kind of moving into building wind farms and solar plants and so on, they have a learning curve. So I think there's uncertainties about how those interfaces will happen between people who are very established in certain sectors but are moving into new ones like renewable energy, and who are having to, I mentioned it briefly at the start, but are having to think about carbon reduction in the way that they deliver projects, which I think, on the back of things like the Shell case last year, that is going to grow, that there is actually going to be much more obligation on companies to find more sustainable ways of doing things, which is quite difficult when you're in mining and energy. They're quite carbon intensive sectors. So I think how that whole sustainability, new energy and carbon neutral piece will play out is going to be tricky. I'm going to quickly mention COVID, because that continues to be a massive source of uncertainty in terms of, how the pandemic is going to continue to play out in terms of the disease itself, but B, in terms of the way that different governments globally are dealing with it. China is still trying to keep everyone locked down. Other countries are starting to think that that's not going to work forever, so that you need to find a way of living with it. And that's going to impact globally as well. Sorry, that was two very big answers. Now, I don't know if you want to pick up quickly on the geopolitical piece or anything else.
I think I'd only say I'd agree with everything you said there, and also suggest that, from my understanding, and I'm no expert on everything that's going on in politics in Chile at the moment, but with the constitutional reform in particular, I think there's a link to the climate change issues and drive to net zero and things like that. I understand that the constitution of the panel who are looking at the constitutional reform is such that this will be a big focus. And so, in a sense, the political and the climate change risks are linked, and there's a great degree of overlap.
Thank you very much. I think you cover all the main factors of arts entities in the way that Chileans are also very concerned and interested. Thank you very much for your presentation. I think it was very comprehensive, very complete. I have questions remaining. I will do it later because we are finishing the webinar. But thank you very much for all your input, and Mark, for your remarks. I hope the audience was glad as I and interested as I was. Muchas gracias por la presentación. Yo creo que fue muy completa y en ese sentido quedan muchas preguntas todavía por realizar. Esperamos que la audiencia haya quedado tranquila con las respuestas y haya quedado satisfecha con las presentaciones. Muchas gracias, Mark, por tus comentarios. También complementaron un tópico que parece ser muy interesante, sobre todo por lo que ha pasado en los últimos 2 años y lo que esperamos va a seguir ocurriendo por los próximos 2 años. Muchas gracias a todos por la participación, muchas gracias a los organizadores y nos vemos en una próxima oportunidad. Muchas gracias.